Thank you. The chair now recognizes Mr. Crank for 5 minutes.
Well, thank you, Madam Chair. I've learned a lot about things today in the hearing, especially I didn't know that Yellowstone or that Yosemite Park must be closed because there was one guy who had a key and now we can't get it open. Oh, wait, maybe there is somebody else who could open that. Look, it's important to me that state and federal partners are responsible managers of species. And Colorado Parks and Wildlife, my state management agency, has in the past done a pretty good job of letting science guide its management. As an example, the Colorado bighorn sheep has never been listed under ESA due to the state's management efforts. And as an avid hunter, I'm proud to have directly contributed to the conservation as I purchased tags for those bighorn sheep for 20 years for a chance to hunt a bighorn sheep. It's currently mounted in my office, and I'd love to have anyone come by if you'd like. Hunters play a critical role in species management and preserving state and public lands, as portions of hunting licenses often fund state conservation efforts. Congress uses the term, by the way, best available science several times in ESA and MMPA statutes to guide the direction of Fish and Wildlife and NMFS in the conservation of the species. To put a species under the ESA, Fish and Wildlife must use the best available science and commercial data to list, delist, or reclassify a species. For the gray wolf, Fish and Wildlife has made numerous attempts to delist the species under both Republican and Democrat administrations as the population has exceeded its recovery goals, but we haven't had success in that delisting. Instead, Fish and Wildlife has had to face serial litigants over every attempt claiming they didn't use the best available science when moving forward with decisions to delist the gray wolf. Yet, groups like the Alliance for the Wild Rockies, Wild Earth Guardians, and Center for Biological Diversity that exploit the best science requirements in ESA turn around and push for gray wolf reintroduction to be included on the Colorado ballot in 2020. So the Center for Biological Diversity profited over $1.8 million in FY23 from lawsuits at the federal government related to NEPA and ESA. Madam Chair, I ask unanimous consent to insert this letter to Governor Polis from September 2022, signed by the Alliance for the Wild Rockies, Wild Earth Guardians, and Center for Biological Diversity, and others to reintroduce wolves to Colorado into the record.
So ordered.
Rather than letting science and data guide the reintroduction of the gray wolf in Colorado, these groups pushed to mandate reintroduction and relied on ballot box biology, leaving little flexibility in the reintroduction program for Colorado Parks and Wildlife. Coloradans who didn't want wolves in the first place now have to contend with them living in their backyards because people in Denver and along the Front Range voted to put wolves in someone else's backyard on the western slope. It's clear that environmental groups use the ESA as a weapon against project development to stifle innovation and to cherry-pick science to adhere to their feelings about species management. Mr. Moore, we have continually seen serial litigants exploit the term best available science in the ESA by selectively choosing different factors, sometimes even administrative factors, to justify litigation on species such as the gray wolf. Do you see in your work instances of how this impacts agency decision-making to the detriment of species recovery?
Without question. The tactics that are used frequently by the environmental groups, particularly the wildlife environmental groups, are an absolute detriment to species recovery and the implementation of both the Marine Mammal Protection Act and the Endangered Species Act. One of the tactics that is in addition to the parade of sue and settle lawsuits that they use to fund their war chests, more recently has been to insert themselves into the Section 7 consultation process. That's a process that is not designed, does not contemplate, and does not authorize the participation by anyone except for the federal agency and the applicant for the permit that's being sought. They have done an end around that process, however, by using public documents such as, or public dockets, such as the FERC docket, to dump tens of thousands or more pages of immaterial science on the agencies at the 11th hour before the agency is getting ready to make a decision, and then claim that the decision that the agency made was not based on the best available science that they injected into the record. Use that to sue, get the attorney's fees when they win, and then use those fees to sue again. So absolutely, it's a process that is broken. It was never intended to function that way, and it's something that needs to be fixed.
Thank you, Mr. Moore.
Thank you. The chair now recognizes Mr.